I'm grateful to all of you for spending time with us today, and your support for the law school, which has been really impactful, is what makes these events happen, both for the Brown Forum and also for the Center for Health Policy and Law that Wendy heads up. So thank you for your financial support, for attending, and all of those things. We're thrilled to have both Professor Emerita Judith Olans Brown and Matthews Distinguished Professor, University Professor Wendy Parmet here to discuss their insights into the U.S. Supreme Court. They have both taught and written extensively about constitutional law, and they've had many a conversation about the topic. That is it for intro. We're going to save some time at the end. Many of you sent in questions. We're going to take some of those questions with about 5 minutes left. Welcome to everyone, and I turn it over to Judy and Wendy. Thank you.
Thank you so much, Miguel. Hey, Judy. Has it really been 6 months since I had an amazing time visiting with you back in Arizona? And I'm not going to say how many years it's been since I used to pop into your office at Cargill Hall. And, what we used to do is I'd walk in, always your office, your door was open, uninvited, sit down. And before you know it, usually with a cup of coffee in my hand, and usually before you know it, we've had a really fun, interesting, enlightening, for me, conversation about what was going on with the courts and the law and the legal system. And I miss that. I miss that so much. So we're going to try to replicate that today over Zoom. Imagine we're not in Zoom. Imagine we're in Cargill Hall. Of course, we're doing this with a few dozen of our close friends watching. But take me back to Cargill Hall, Judy.
Wendy, I love being retired. And since I've been retired, I've taught part-time at the University of Arizona and Dartmouth, and I have taught with various other people who claim to know something about the Constitution. And I really miss doing it with you. It's not even close. So thank you, Miel, and for all of you to keep requesting this so that we can keep doing this at least once a year. I thought I'd start us off with a very provocative quote that I found recently by a fellow named Ian Millhiser, who is a commentator on the court, and I think a pretty good one. Here's what he wrote in July. The justices take liberties with the facts of their cases. Here's a shout out to you, Justice Gorsuch. And they can't even be trusted to read the plain text of an unambiguous statute correctly. In just the last few years, they've overruled so many seminal precedents that law professors no longer know how to teach their classes. If the justices did not wield such awesome power, and if lawyers who practiced before them did not have to treat them with ritualized obsequiousness, isn't that a nice word, obsequiousness? Most of the justices would be laughingstocks. Few people this famous are so ostentatiously bad at their jobs. So I guess my question to you to get us started is it really this bad? But before we answer that, as you and I have talked about so much over the years, constitutional law, especially at the court, always featured the overturning of cases and some politicalization, both in the appointment of judges and in the way they approach cases. Bush versus Gore is, of course, the prime example. In addition, doctrines have changed over time, and the composition of the court, of course, always mattered. The Rehnquist court was different than the Warren court, so elections matter. But still, the quote I just read captures a pretty important truth. It feels really different these days. Doctrines aren't just evolving, as you said to me. They're being shattered into irrelevance. Sometimes it feels as if there's no doctrine or none of that matters. I used to think that legal doctrine or legal arguments, if carefully structured and persuasively made, that there were enough justices in the middle that you could convince that you were right if you were smart enough and clever enough. I don't think that's true anymore, and that scares me. Arguments don't seem to matter. The text of the Constitution doesn't seem to matter. You used the phrase when we were talking about doing this, that arguments before the Supreme Court have become kabuki theater. I think that's right. So if I'm right and you're right, that doctrine doesn't matter anymore, what does? What replaces it?
So one answer, I think, that at least a lot of constitutional law scholars would give you is history or originalism. At least that's what many of the justices say. And we could talk a lot. We could talk for hours about this, but I'll make a few points. One is that we should note that history and the use of history and originalism are not identical, though the lines often blur in the court's opinions. To oversimplify, originalism, as it has evolved as a theory, now usually insists that the words of the Constitution were fixed. That's the word the proponents use at the time of the Constitution's ratification. So judges are supposed to look at what the framers and other legal elites would have understood at the time of ratification. And often this leads to an examination of legal history. But we should know judges often apply history in a looser way that drives some of the proponents of originalism bananas, right? History can also mean looking at sort of tradition and where the law has been for a long time. And courts often look at different moments of history and a different level of generalities. And the, originalists and people who write about originalism, entire forests have been spilled discussing these finer points and the distinctions. But I want to make just a couple of points. First is, whatever approach you use, the dead hand still rules, right? Second, it's worth noting that originalism as a theory was originally proposed in the 1970s and 80s as a theory of judicial restraint. Conservative critics of the Warren Court, and Roe versus Wade in particular, argue that courts should not make up, as they saw it, new rights that were not in the Constitution or understood to be there by the framing generation. The claim was that all those things that the framers didn't intend should be left to the political process. So originalism was sold to us as majoritarian. But it has become very much the opposite. Instead of limiting judicial power, it expands it today by placing almost every enacted law, state or federal, on the judicial examining table. Does this law pass muster based on history, whatever that means, as the court decides it on a given day? Even if the law has been supported by decades of precedent, doesn't matter. Every law can be examined anew. It's a type of constitutional fundamentalism. In this way, and I think this explains what Millhauser is getting at about precedent. Precedent is precarious. And the doctrine that evolves from precedent, that you and I had so much fun talking about and debating and parsing and playing with, it's kind of irrelevant. Because every new law, instead of asking what is the doctrine, can be, it's not always, the court is inconsistent about this, but every law can be looked at anew. Does it meet the history test? And of course, the test is given by the judges. So they, not elected legislatures, not presidents or governors, become all important. But what is history? Not only does the court approach to what they mean by history varies, but of course, we need to ask whose history, right? Whose history matters?
Obviously, I'm sorry, go ahead.
No, please, take it away.
I mean, obviously, our past is relevant, or we think it is. I'm not so sure anymore that it even passes the relevancy test, particularly after the immunity cases, but we'll get that later. What you're saying makes me want to ask, to what is history relevant? To what is the past relevant? And whose past matters? Those who were powerful enough to make the laws and create the history, or those who were marginalized and couldn't participate in the political process? Remember way back when Caroline Products strict scrutiny to protect the rights of those who lack access to the political process. That's from the 30s, and we don't seem to care about that anymore. So here's a couple examples, some obvious ones. Dobbs says, since abortion was illegal in the 19th century, the late 19th century, there's no history of abortion in the United States. Well, that's nonsense. Of course, women couldn't vote until 1920, and there is a rich and well-documented history of the availability of abortion during the framing period, when women and midwives made the family planning decisions. So why assume that the lack of the explicit word abortion means that there was no right at all? I thought we were supposed to be looking to the history, but the date of the history, as well as the authors of that history, seem to be moving targets. Why not say that the lack of legal protection means they weren't needed because abortion was assumed to be available? So what's the default? And more importantly, why lock ourselves into the biases of the 18th and 19th centuries? Remember Justice Scalia saying over and over and over, the Constitution is dead, dead, dead. If it's true that abortion rights were not established in the framing generation, and therefore were not fixed in the Constitution, why should we care about that today? Why must dead hands control? Can the Constitution, should the Constitution set the rules if it forces us to live like people lived in the 18th century? You know, this is the question, obviously, of constitutional law. The Constitution is an aspirational document, and how should it be modernized? How should we interpret it? When the Constitution was written, there weren't very many rights being protected. There were some rights of property owners, which probably meant slave owners. There was an idea that there should be no king. There was an idea that there should be no official government religion. Well, a lot of those things have changed. But the question I have is, as we evolve new rights, how do we ground those rights in the Constitution in such a way as to protect minorities and prevent majoritarian tyranny? And I don't know the answer to that question anymore.
I certainly don't. But I want to say, I think, you've asked even the really big question. The bigger question than the question of how do we ground rights is, if the Constitution is, if it must be, as the court says it is, and if, as I think we're going to discuss, that has some of the implications that I fear it has, a couple of ifs in there, then why our fealty to it, right? I mean, we're not supposed to say that. We're all supposed to pledge our fealty to the Constitution. And yet, the really big question is, if the Constitution, is it, so to speak, a suicide pact because it completely disables a contemporary society from existing? And I want to get back to that. But I want to talk about one case decided last term, which I think showcases how at least some of the justices are kind of recognizing that problem and trying to worm their way around it, at least on occasion. And that is the Rahami case. So back in 22, same week as Dobbs, one of the Supreme Court's great weeks of all times, the Supreme Court decided, in an opinion by Justice Thomas, right, the Bruin versus New York Rifle Association case, and the court expanded Second Amendment rights, right, castigated, here's the anti-doctrine, all of the courts, lower courts, because they had unanimously applied a balancing test, sort of an intermediate scrutiny for deciding whether state firearm regulations violated the Second Amendment. No doctrine, no balancing test. Instead, Thomas insists history is the sole question you need to ask. The only question is, can you find a regulation very similar to similar, that's not the precise word, but can you find an analogous regulation in the 18th century to the regulation at hand? And if not, doesn't matter what the balancing test is. Doesn't matter if getting rid of this regulation will lead to, 1 million deaths tomorrow. Consequences be damned. The only question is, was there an analogous regulation? Which obviously, it doesn't take a lot to think this is a little bit batty, right? I mean, right? The world is really different. Firearms are really different. Lethality is different. Yeah, they didn't have the same regulations for muskets as they might have for machine guns or nuclear bombs or things, right? It doesn't take you much far. So lower courts were having a lot of trouble applying Bruin, not surprisingly, because they kept coming up to the fact that the implications of Thomas's decisions were ridiculous, right? Mm-hmm. And one case in particular, it was Romney, the Fifth Circuit case, where the Fifth Circuit ruled that federal law prohibiting people subject to domestic violence protective orders, because a judge had adjudicated them as violent and dangerous, the law prohibiting their possession of firearms was unconstitutional because there was no domestic violence protection order and nobody stopped people, domestic abusers. I mean, one judge even said, well, wife beating was okay back then. So you can't say you can't have a gun to kill your wife now, right? I mean, and this really was the absurd. And what's interesting is last term in Romney, the majority, and in another opinion by Roberts, and we'll come to Roberts because he sure was busy last term, Roberts steps back from the implications of Bruin and says that no, you don't have to look for the exactly analogous decision. The Second Amendment is not, stuck in amber, but rather the court should rely on the broad principles that underlie the nation's regulatory tradition. In effect, he tries to save originalism from its own obvious consequences by avoiding a clearly absurd and unpalatable result. Imagine the headlines. Supreme Court says domestic abusers can have guns and can shoot their wives, right? I mean, that wasn't going to be a very good headline. But that has to... The story is, well, then why still the insistence on originalism, right? If using history is meant, as the original proponent said, to remove the court from having to make value judgments, well, isn't the court actually using a value judgment here? And isn't it's now opening the door to broad principles, really saying, well, value judgments come back in. We really didn't mean that people, domestic abusers can own weapons. So does it give us any coherence? We've thrown doctrine down the drain and now we're using history, but history can sometimes be very, very specific, as Thomas continues to insist, or broad, as Robert says. So what have we come up with? Is this any less dispositive than the type of doctrine it has replaced?
Exactly. I mean, all of these doctrines, history, originalism, and its close cousin textualism, which they use when originalism doesn't get them where they want to go, have been sold to us as ways of ensuring careful, judicial, self-restraint type analysis of cases. And of course, that's hogwash because the opposite is true. Look at this year's election cases as a good example of that. The text of Section 3 of the 14th Amendment is crystal clear, as is the intent of its drafters. Let me do it this way. The language in the ballot, who should Trump be on the ballot case, ignored the plain language of the amendment. Indeed, it openly nullified the language of the amendment, barring insurrectionists from holding public office. The inquiry should have been, was Trump's behavior on January 6th and around that time the kind of behavior to qualify as being an insurrectionist within the meaning of the 14th Amendment? The court never got to that. They rushed to judgment and said, well, we can't do that, because think how confusing it would be if every state had different rules for elections. Well, if you read the election clause in the Constitution, it says it's perfectly fine for every state to have different rules about elections. And I can't resist. Dobbs and Trump on the campaign trail says it's wonderful that every state can have different rules about abortions, but we can't have that kind of confusion about election laws. So it's kind of like a dog that chases his own tail. And in the immunity case, it's the same thing. The court invented, with absolutely no textual support, various forms of broad presidential immunity. What kind of an originalist court is it? What kind of a fidelity to text court is it if it fails to follow what it claims to preach in the term's two biggest cases? Similarly, in the federal the obstruction of justice statute in Fisher, the court said that the January 6th insurrectionists and rioters did not, to use the unambiguous statutory language, obstruct or impede the congressional proceeding to certify the election. The Chief Justice ignored the basic rule of the fidelity to text crowd, that a legislature meant what the statute said, and the legislature said what it meant. Justice Barrett, which was a surprise to see her saying this, said, Justice Roberts said the legislature couldn't have meant that. That's a, quote, textual backflip, just because the justice cannot believe that Congress meant what it said. So he's going to change the statutory language. Remember those balls and strikes he's so proud of and he's always talking about? This isn't a ball or a strike. It's a rewrite of legislative language. The justifications for the court that the court tries to give are silly. I mean, and it's hard to escape the conclusion that they're really motivated by political bias. In all three of these cases, the court failed to focus on the actual facts of the case, the conduct of the parties before it, but instead anxiously hypothesizes about fantasy future interpretations and parades of horribles, concluding that it has to rewrite the statute and rewrite the Constitution to make sure that those imagined nightmare scenarios would not occur. Shoulda, woulda, coulda. I mean, this is absurd. One of the things I most liked about you and I and Mary O'Connell wrote an article one day about Sandra Day O'Connor. And we all concluded that one of the things that we most liked was her insistence on fact-based inquiries to resolve the immediate dispute between the parties. She hated what she called grand style theories, in which the court often indulged. Whenever I think about that, I remember towards the end of his career, Thurgood Marshall saying, I used to believe in these grand style theories, but they really don't work anymore. But I guess if you're writing for the ages, as Justice Gorsuch so arrogantly suggested in the immunity case, you're free to ignore the facts in front of you, what the parties actually did, and instead give yourself the luxury of speculating about future horrible events. Writing for the ages is a long way away from balls and strikes. So that's a long-winded way of saying that this is all nonsense and that these theories have been sold to us as a way of guaranteeing value-free judicial judgments, as a way of guaranteeing judicial self-restraint is utter nonsense. And now I have to ask you, does this fit for all, this is your stuff, the administrative law cases.
Well, before I get there,
future parade of horribles. There you go.
Future parade of horribles. But before I get to that parade of horribles, I just want to underscore and say, I think what you said in a somewhat different way, which is, I said a few minutes ago, like, it doesn't matter. It doesn't matter how many people die, right? And, but it's interesting, right? Because when the court wants it to matter, when the court wants to be consequentialist, as in the immunity case, oh my God, what would happen to some other president? Suddenly they're consequentialist, right? One minute they tell us they shouldn't consider the impact of what they do. And obviously for me, as a person who, spends most of my time thinking about constitutional law through a public health lens, one day, it doesn't matter if lots of people die. Hey, we can't do this. And, I can point to decisions where they kind of pretty much, especially Gorsuch, say it doesn't matter how many people die. Can't do this. And then the next day, well, hypothetically, some future president, or it might cause chaos. And, they care about the consequences they care about. But maybe that's inevitable. Maybe we all do that. But I think what is so deeply disturbing and undercutting of their legitimacy is, on the opposite day, they claim consequences don't matter. And, people will die. Women will die, right? We now have, the first report of a specific named woman who died because of dogs. That doesn't matter. Not our department. But when they wanted to be there, you can't claim it's not your department if women die. And then, well, it is your department to worry about how this might affect presidents in future generations. You can't play it both ways and expect people to respect you.
Yeah, well,
and O'Connor always said it mattered, just that it matters. And you get it right sometimes, you get it wrong sometimes. But let me turn to the
Let me add one more thing before you do that, because I know you have a lot about the ad law stuff, and I want to give you plenty of time to say that. But what really scares me about the conversation we're having, and a conversation I suspect lots of people, lower court judges, law professors, law students, anyone who cares about the court are having, is if you and I can sit here and point out how hypocritical they are, that does not bode well for respect for the judicial system in this country. And if we push that out a little bit, and people think that the judicial system is politicized, perhaps even corrupt, there goes one of the founding myths of American constitutionalism, the rule of law. And that really scares me. I mean, it's fun to sit here and say, weren't they stupid to do this, that, and the other thing? But I think there are significant consequences to these conversations happening.
No, I agree. And I think we're going to come back to some of that in our conversation. So I do want to turn to some of the major developments in the administrative law area. I do want to say, I don't think they're stupid. I think this is very intentional.
Absolutely.
And we should underscore that.
But I do want to
I do want to talk about the administrative law cases, including Loper Bright, which overruled Chevron, of course, last June, and some earlier cases that created the so-called major questions doctrine. Now, technically, sort of, kind of, these are not constitutional law cases, right? They have to do with statutory interpretations, interpretation of the Administrative Procedure Act, etc. But, they reflect the same dynamics that we've been discussing. And in fact, in many of these cases, the court's opinions rest, I would say, in the shadow of constitutional law. And you get, in some ways, that same concern about their vision of separation of powers. There is an irony here, which I will just say up front, right, which is, in the election cases and the immunity cases, you see a court saying, if we need to have a robust executive, right, very robust. And then in the administrative law cases, you see a court really decapitating the executive. And I've read theories about how this all fits in with conservative legal theory, and we could talk about that. But I do think there's a implication to that dualism that I want to get back to, I hope. But let me talk about these cases, because they really are very similar to the common law cases in many ways. First, again, we see the erosion of stare decisis, right? Just don't matter. the desire to upend even well-established precedents. Everything's going back to first principles. So Chevron, Loper-Bright, go back to first principles. We'll read the Administrative Procedure Act as if, this is 1947 or something, and there hadn't been 60 years of interpretation. Just keep going back to first principles, right? That same kind of fundamentalism. Second, there is a kind of nostalgia, as we see in the con law cases, for an imagined past. Here, it is a past that the justices imagine, the halcyon Eden before the New Deal, where there was no regulatory state and, entrepreneurs were not burdened by these awful regulators. Third, there is this inconsistency between their supposed fidelity to text and the vision of originalism as a restraint on judicial activism. And that is clearly evident in the major questions doctrine cases. There are cases where the statute clearly says, and such other measures as the secretary may find reasonably necessary, and they just wipe that out, right? Again, under their view of that just can't be. Yet they can point to no language in the Constitution that actually demands the outcomes they insist upon. Right? And though the court claims that the decisions that they are reaching are preserving congressional authority, they're really not. They're making it harder for Congress to act, and we know how hard it is for Congress to act anyway. And the only winner, again, is the court, right, which gets the power to decide what regulations are okay, how should we have our pandemic response, how should we deal with a housing problem, a student loan problem. It's going to all be up to all policy making now is moving to the justices. Now, this raises another point. In the administrative law cases, including Loper-Bright and Corner Post, which basically got rid of a statute of limitations in cases challenging federal regulations, the court, again, totally, as with Dobbs, disregards the chaos that will ensue if we get rid of agencies, despite some powerful dissents suggesting this. Indeed, and I think for me, this is increasingly becoming an important theme. Many of these cases seem not only designed to create chaos, but to disable government. If you believe that the government is the deep state, if it is the other, then that kind of makes sense, right? And it's odd, right? You want to have a president that is all powerful to break laws, but you don't have a president that's powerful to actually implement or administer the law. We will have a king that struts around on his throne with his scepter, and I'm using the male gender here purposely for obvious reasons, right? I know we may not have a male president, but I think if the image in the court's mind, right, in the Trump case, right, was Trump, you can have this all-powerful monarchical president, and yet the president can't have his EPA do what he wants, what he promised on the campaign. If a president is elected on a promise to deal with student loans, he can't deal with it, right? So you have this oddity here. You have this very ironic duality. But what's really terrifying about it, right? Two things. One is, how do we function as a country in the 21st century? If all policy initiatives end up dead on the floor because 5 justices think they're dead, if every promise made by an administration cannot be enacted because 5 justices stop them. We have a thing right now, I like to say to people sometimes, if Biden sneezes, 23 Republican AGs will go to the Fifth Circuit, get an injunction, and the Supreme Court will accept it. You have a president who is completely, people don't think Biden did this, or this. What could he do? Everything he tries to do is enjoined, right? And based on, right, a court's view that this wasn't there in 1789, or they think it would be chaotic, or it violates their understanding. So how do we handle climate change? Court says you can't. How do we handle AI? Court says you can't. How do we handle future pandemics? Court said the government couldn't do what they did last time. How do we handle any other challenges that we have as a country? And does that disabling of government You know, people are angry. Government's dysfunctional. Government doesn't make Americans' lives better. The court has played a role. And I'm not saying it's the only factor, but it has played a role, and an increasingly, I think, dangerous role. And when people are angry and they're dissatisfied and the government can't resolve their problems, doesn't that help push some people to the strong man who he alone can fix it? Because normal government doesn't work, but it doesn't work in part because of a court, and no one's looking at the court. And that leads me to another point. Is there any vision here of what a country should be, of how a country of over 350 million people, right, across a continent in a very complicated world, how are we supposed to be? Like we were in 1789? Come on. Is there any vision here of the future for this country that the court, or is this just partisanship? How else can we understand granting a president who has been convicted of felonies immunity while also saying that the president lacks authority to, you know, EPA cannot, has no expertise and deserves no deference about clean power plant rules, right? Is the president a king or a knave, or does it matter? Do we think a Republican president would get the same treatment with the clear under Loper Bright or clear major questions doctrine? Now, I want to just quickly, before I go back to you, Judy, say, here's what somebody, I suspect someone there is saying to me, but wait a moment, Wendy. There were several decisions this year that we haven't yet discussed, such as Alliance for Hippocratic Medicine versus FDA and Moyle versus USA, where the court seemed to step back, where it seemed to, you know, both decisions based on prudential, based on Hippocratic medicine, based on standing. The challenges did not have standing, the court said, to challenge the licensing of mifepristone, abortion medication, or Moyle. The court said that the grant of cert was incorrectly given and it wasn't going to decide whether the Biden administration's guidance on EMTALA and abortion was inappropriate. So, you know, isn't the court occasionally being sort of careful, circumspect, moderate?
No.
But we'll get to you. I think, at least in the abortion cases, there's another reading. The court was just punting in an election year, didn't want to give the Democrats another issue to run on. So they stepped back on standing. But there are decisions, there are concurring decisions which outline the attack to come. I don't think we should trust that the court is being prudent or modest. They have not earned that trust.
I know this is sounding increasingly conspiratorial, but I think you're absolutely right. Justice Kavanaugh in the mifepristone case says, this group of plaintiffs didn't have standing, but listen up. Here's who might have standing next year. See you next year. I think the court does have a vision, and it's a very, very dark vision. And it's a vision that, or an agenda, maybe it's not a vision, it's an agenda that people like John Roberts have spent their lives fulfilling. Keep people of color from voting. He did that for years in the Justice Department. Get rid of government, get rid of agency power. He did that for years when he was in the government. So I think all of this is very deliberate. But you know, when Justice Roberts was nominated, in comes this preppy boy in a bow tie, and people said to me, oh, he looks like us, he talks like us, he's fine. And I said, read about what he has said, read what he has done before he ascended to the court. And you and I have said for years, he wants to be known as King Solomon. He doesn't want to go down in history as a hack. Well, the New York Times, and you and I have said, but he's really a hack underneath all the Brooks Brothers clothes. And the New York Times on Sunday said, oh, what Judy and Wendy have been saying for years is absolutely right. But if we look at what Roberts has done this term, he looks less like someone who wants to broker compromise. He looks less like an institutionalist. He looks like just another far-right partisan. And he's no longer trying to hide it. His response in the majority opinion in the immunity case to the women, and I say that advisedly, who dissented, was really insulting. And maybe I'm exaggerating, but when I first read it was, now, little girls, go home and mind your manners. He usually, when the majority disputes the dissent, they're not caustic, they're not sarcastic, they're terribly formal. There's a tone in that that was really upsetting. And when they said to him, you're casting aside all of the precedents about presidential immunity, you're openly inviting criminal conduct by future presidents. He was very angry. How dare you call me out on that? So as Linda Greenhouse, I love Linda Greenhouse, says, Robert seems to have given up on his efforts to ensure the increasingly concerned public that the court deserves their respect. So I'm not a psychologist, but why has he done this? Is it, if you can't beat them, join them? Is it because of the ethics situation that he has been unable and unwilling to handle? I don't know, but I think it bodes very badly that he's not at least going through the motions of trying to be careful, lawyerly, neutral, restrained. That scares me. I mean, it was fun for us to sit back and say, well, he's really a hack, a wolf in sheep's clothing. But he'd taken off his clothing now. And I'm not sure what that means for future cases. He's not even trying anymore. And he doesn't seem to want to.
I think that's true.
Am I going too far with that?
No. I mean, I was thinking about, I saw both him and Thomas speak in 22, saying 2 days, one after the other. And, Roberts was you couldn't, even though you might not agree with him, he was smooth. He said all the right things. He said all the things about the rule of law, and he praised people, all the people who were all the lawyers, and he was, it was very anodyne. And then Thomas comes in, and honestly, I wanted to build a survival shelter for myself. I mean, the man terrified me. His anger just oozed. I had never been in a speech like that. It was literally scary. But Roberts wasn't like that. You couldn't be angry at him even when you were angry at him. And I think you're right. I think he's changing. I also am not a psychologist. I'm not going to pretend. I will note, right, that the movement of which he is a part and the circles of which he is a part, the conservative legal movement, the Federalist Society, the Republican Party, they have all moved, right? I mean, he could sort of be a moderate in the world of the Bushes and the Mitt Romneys and the John McCains. And his circle, it's not just that the court, that he's not the center of the court anymore, but it's also the world he's in. Mary Ziegler made a very, the scholar about abortion, but made a very, to me, insightful comment about how, we all hear about our legal community, right? Our professional community, right? So, Judy, you and I are talking today, and we care about what all of our alums are thinking, but we're probably not so upset about if, the Federalist Society folks are just think we're ridiculous, because that's not our community, right? The Northeastern community is our community. But his community has changed. And so lots of legal scholars are criticizing him. And yes, obviously Trump was wrong when he said every legal scholar wanted Dobbs to be overturned. But lots of legal scholars, lots of lawyers, lots of mainstream lawyers, lots of moderate Republican lawyers are criticizing the immunity case, but that's not who he has lunch with.
That's right.
That's not his community. That's not his law clerks. They're getting them from the Federalist Society. So the world in which he is operating, where he wants the pat on the head, is actually not the American public. I think
That's
it's
right.
true for all of us. It's our own community.
I read something yesterday on one of the, I read the Times and the Post, and I can't remember where I saw this, but one of the op-ed columns said, Roberts, quote, thought the immunity decision would soar above politics. And I thought, what world does he live in? When the conservative, very conservative legal scholars like Michael Lutig criticize the opinion. And all I could think of when I read that was his oft-repeated mantra is, discrimination is dead. We don't need to have civil rights protections anymore because there's no more, even if there ever were discrimination in this country, it doesn't exist anymore. And there's this wonderful case, I think it's called Chouette. It's the Michigan affirmative action case. It's maybe 15 years ago, where he writes this. And Justice Sotomayor, in one of her earliest wonderful dissents, says, listen up, white boy, you don't understand that I live in a different world than you live in. Let me tell you what it's like growing up poor. Let me tell you what it's like growing up brown. Let me tell you more about this country. And as I read that he thought that this immunity decision would soar above politics, I thought, whoa, he doesn't live in that world anymore.
But he doesn't. But maybe the court, like so much of society, has become victimized, right, by the increasing polarization and siloing of our communities, right? People don't bowl with people with different political beliefs. Everyone isn't watching, the CBS Nightly News with Walter Cronkite, right? People are in their informational bubbles and silos. And maybe it isn't surprising that the justices are also, right? They're in their world. And in their world, right, the problems that Justice Sotomayor talks about are not visible, because that's not what you see if you're in their world. And, I think, that's probably true for all of us. But Judy, we are coming short in time, and I know Miel wants to leave a few minutes for questions. So I just want to ask you, any hope? We don't want to leave all these people completely despairing.
One of these classes I taught at the University of Arizona was with a guy who said, you always have to leave people with an optimistic note of hope. I don't have any. I really don't have any. I have a tiny theory that's pretty inchoate and I think overly modest, which is if we win the election and if we win the Senate and if President Harris appoints a lot of lower court judges as fast as they can ram it through the Senate, maybe there will be some pressure bubbling up from below from the lower courts saying to the Supreme Court, we don't know what you're talking about. And if we think what you're talking about, what we think you're talking about, we're not going to go along with it. That's pretty pie in the sky. I mean, when I'm really discouraged and that's all I can come up with, not good, not good. I know Miel wanted us to talk about court reform because most of the submitted questions were about court reform. What do you think? Is it ever going to happen? I don't think it's ever going to happen. And I've got a whole bunch of reasons why, but your turn.
Gee, talk about optimism or lack thereof. The problem is we're in this vicious cycle, right? Where we have a court that has, and if we had more time, we could talk about this, has played a role in exacerbating the political dysfunction in the country, right? Mm-hmm. From the immunity case to, we could talk about a lot of the voting rights cases or their evisceration. Thank you, Justice Roberts, of the Voting Rights Act. I mean, we could go on and on about that. So the court has played a role. It's certainly not the only factor, see social media. But it has played a role in the increasing dysfunctionality of the political process, which then makes it harder to change the court, right? So the problem is, how do you get court reform when you have continuously closely divided Congress, when you have a court itself which seems hell-bent on policing any statutory changes that affect it, because I don't see them easily accepting limits on their power. Obviously, we can make great legal arguments about why, various measures are constitutional, but you got to trust them that they would follow. The precedent don't matter anymore, right? And so we're in this vicious cycle. I think it's important to keep talking about court reform, because it is a way of putting the illegitimacy of the Supreme Court in the political space. But I don't think that there's a quick and easy answer other than, this too shall pass. And the one note of optimism I will say is that in a world in which precedent has no salience, the next 5 justices don't have to listen to anything these 5 say, because precedent is worth the paper it's written on.
Yeah, I think that's right. And if you look at, everybody agrees that the institutionally best solution is term limits or mandatory retirement ages, or however you structure it. And that takes a constitutional amendment. And if Congress tries to do that by statute, the court's going to say it's unconstitutional, and they probably would be right. The one that interests me, just because Justice Kagan has been talking about it a lot, is ethics reform. The court's attempt at ethics reform was laughable. If Congress were to pass a strict, or if the court itself, well, the court itself will never do it, but if Congress could do it, would the court say it's unconstitutional like they would with term limits? Alito says the Congress has absolutely no authority to regulate the ethics of the justices, and probably no authority to regulate other matters as well. I can't resist saying this. Here's Justice Alito, who says, my wife has absolute agency. I cannot interfere with her free speech right to fly whatever flag in whatever position she wants. But of course, she can't make decisions about carrying a pregnancy to term without my intervening. Come on, who are you kidding? I just couldn't resist that. So, but Roberts...
Well, I love chatting with you, Judith.
Sorry, go ahead.
No, I was just saying, that's why I love talking with you.
Right.
It's the things you can't resist saying.
Roberts has also refused to testify about ethics at a congressional, and when Senator, I think it was Durbin, one of those guys, wrote to him and said, will you come meet with us and have a conversation? He refused to do that. And so recently, Justice Kagan suggested publicly that the court adopt a stronger ethics policy. And then some conservative activists, including Ginny Thomas, they used to call the Solicitor General the 10th Justice. Somebody said to me the other day, well, Ginny Thomas is really the 10th Justice. Ginny Thomas said, stronger ethical reform or stronger ethical proposals are somewhat treasonous. And to which Justice Kagan responded, that's like being somewhat pregnant. And I loved it. But I don't know where you go from here. I really don't know. I guess I have to say to all of you out there who Wendy and I have taught for years, I'm sure glad I'm not standing up in front of a room full of 27-year-old kids who want to save the world, because I'm not sure I know how to do it anymore. And that makes me very, very sad.
Well, Judy, there's a reason, and this suggests that these problems are longer rooted than we've been talking about today. There's a reason I left common law for torts. Yeah. Because honestly, you can see the problems, and it's very hard, because I do think, and going back to what you said about rule of law, it is important, I think, that each generation of law students have not unquestioned faith, not naivete, but some belief that it matters, that what they do matter, that the fights they fight, the good fights they fight, the good arguments they make, the hard work that they do can make a difference. And I think it can at many levels. We're talking about the Supreme Court, but that's not what goes on in, Superior Court every day. And if it's going to get better, it's going to get better. Things are going to change. It's going to change from their generation, from a generation, not our generation. But it's very hard. It's very hard. I was talking to a current student, recent grad rather, who's about to take the bar, and it's like, how do you even ask a bar question about the common law? Like the bar keeps asking questions as if any answer is there, as if precedent matters, right, when precedent doesn't. So I reached a decision years ago that I was going to escape to the common law, where no one court or no fifth justice rules, where things happen at a slower pace. And so there is evolution and there's dissent in different cases. And even though I still write about constitutional law, because I think it's very hard. I think it's very hard. And there have been a lot of discussions on the common law reserves. How do you teach? You could teach it as political science. You could teach it as history. You could teach it as critical theory. But how do you teach the positive law of common law right now? It's where you started. That's what Ian Millhauser asked. And the answer is, I don't really have an answer for his question.
I just add one more footnote to that. There is a theory that you can teach constitutional law through a series of crises. You and I have talked about doing this, but the first and most obvious crisis is the Civil War. And it was a crisis because all of the other institutions of government broke down. Congress passed the Missouri Compromise, which was supposed to, one from column A, one from column B, solve the slavery problem. The Supreme Court in Dred Scott said the Missouri Compromise was unconstitutional. No one could solve the problem of slavery. And the court tried to solve it itself, and it didn't work. And so the solution became military. That's really terrifying. The next crisis was the Depression, and it was solved by administrative agencies and government.
And Congress.
Yes, and Congress. The opposite of that is happening today. The court is taking the power away, even though they say they're giving the president power to be a king and never be criminally prosecuted. They're taking power away from the executive branch. They're taking power away from Congress, and they're arrogating it unto themselves. That's not good. And it's not going to work. There's 5 guys, 4 women, a bunch of law clerks, and a skeleton administrative staff. Those are the people who are going to decide how much pollution the EPA is permitted to regulate.
Not to mention, they don't even know the names of the chemicals that make the pollution, as we saw
right
this term. I mean, that's, no deference to agencies, but, these folks don't know any science. I mean, nor should they, right? I mean, it's not a criticism of them to say they're not, environmental scientists. They're not biologists. They're not geologists, right? They're not economists. I mean, no one person, maybe ChatGPT, I'm kidding aside. I mean, they cannot know everything, and disabling, again, it's very scary. But we're supposed to end optimistically.
Yeah.
So it's always fun to talk with you.
Yes, we talk out, believe it or not, we talk outside of these conversations.
I believe it. I'm going to step in here and tell you a couple of comments. We've had people say this is feeding their soul. The series has fed their soul, and we appreciate you commenting on recent cases and sharing your thoughts. I had someone say it's so nice to stretch my brain in this way, and this is really helpful. Judy and Wendy, I think you're onto something with maybe the ethics angle. I feel like that might be the way, because there's been all these egregious yacht rides and travel. And I mean, if that isn't something that can switch it up a little, I don't know what is, but that gave me a little bit of hope. But I'm so grateful to both of you for making time in this very busy fall for your thoughts and your wisdom and the things that you've seen and read. And I know our group is as well. Any final comment from both of you?
Thank you, Mia. Thank you so much for organizing this. Thank you to everyone who's joined us. Thank you to Judy, and I hope we do it again, both on camera and off.
Thank you. Thank you for giving me an excuse to work with Wendy again.
Of course. I adore you both. Thanks everyone from all the coasts and in the middle for being with us and for supporting our programs at Northeastern Law. Have a great rest of your day.